So, as I said, I'm not really going to get into specific substantive issues. If you have a question about residency, or you have a question about statements of economic interest, or you have a question about if you don't file your receipt for a statement of economic interest, please go to the index of Electoral Board Decisions and look it up. You can do some quick research on the subject and you will find whatever board decision is out there on the subject. Now, I'm going to throw a quick caveat out there, all right? The index lists all the Electoral Board decisions. It also lists if that decision was appealed, it will show either a circuit court decision, or it will identify a circuit court decision, or it will indicate a decision of the Illinois Appellate Court, or a decision of the Illinois Supreme Court, or a decision in the federal courts. Those decisions are not hyperlinked. So you'll have to look those up on your own if you want to see those decisions. There may be other decisions out there that do not involve a decision of the Chicago Board of Election Commissioners, but may involve the same point of law. So I urge you, if you find a decision in the Electoral Board Index, be forewarned that may not be the final statement of the law currently in the state of Illinois. You may need to do some research and look it up. However you may, whatever resources you have, there's the library, Cook County Library across the street, the Daly Center on the 29th floor. So you certainly could do some research over there. But just realize and understand that the index is not necessarily a final statement of the law in Illinois. All it is a listing of all of our Electoral Board decisions and case law affecting our decisions. So as far as the process is concerned, and we'll just follow the PowerPoint, copies of which you should have, but we'll discuss these as we go along. The first 2 points there reiterate, I think, what all of you know. Voting is so fundamental to our system that the courts have recognized that it is protected in many forms and many shapes, including access to the ballot. And our Illinois Supreme Court in Welch versus Johnson said it is a ballot access is a substantial right and not lightly to be denied. But as important as it is, there are also case law decisions that point out that the state's interest in keeping its ballots within manageable and understandable limits is of the highest order. We don't have a situation like you might find in California, for example. In 2003, in the state of California, they had a recall election for their governor. Mr. Davis was recalled by the choice of the voters, and there was an election to fill the subsequent vacancy in that office. There were 135 candidates on the ballot at that election for governor, for a single office, 135. Only 4 of those candidates obtained more than 1% of the vote. The rest of them just split it all up into small, tiny splinters. Most states, California is the exception, most states do impose certain requirements so that you limit the ballot to those candidates that show a modicum of support, some support in the community. And the way that Illinois does this, and the way a lot of states do this, is they impose minimum signature requirements. And the signature requirements are different for every office. But, for example, in the city of Chicago, for the office of mayor, city clerk, or city treasurer, the minimum signature requirement is 12,500. You need to go out, a candidate needs to go out and obtain from registered voters in the city of Chicago signatures equaling not less than 12,500. If you do that, you've demonstrated you have support in the community sufficient to qualify for the ballot in the city of Chicago. So that is the means by which Illinois has chosen to winnow out those candidates that have community support versus those that do not. There are also other requirements. They'll set certain eligibility requirements. So for example, there may be residency requirements. You have to live in the jurisdiction for a certain period of time. For the city of Chicago, it's a 1-year durational residency requirement, both for aldermen and for city clerk, mayor, city treasurer. So those are requirements that are discussed, again, in the election information pamphlet and calendar. It's available on the website, and I invite you to look that document up and read it through carefully. But again, I want to focus on just the process here. Section 10-8 of the Election Code says that nomination papers being in apparent conformity with the requirements of the code are deemed valid unless a written objection is filed within 5 business days after the last day for filing those petitions. Now, this is important because some people think that if no one objects to their nomination papers within that 5 business day window, they're home free. They're on the ballot. They're already out there celebrating. It isn't necessarily so, because there's a doctrine which I will go into more detail toward the end called the Doctrine of Apparent Conformity that may result in a candidate's name not being certified to the ballot even though there's no objection filed. But right now I want to focus just on the objection process. So the statute has set out a remedy for objecting to candidates' nomination papers. It is the exclusive remedy. This is the only way that a candidate's nomination papers can be challenged legally. So that if an objection is not filed within 5 days, if you're interested in objecting to your opponent or to your neighbor, whoever it is you want to object to, if you don't file your objections within 5 business days, you're out of luck. Because Illinois law is clear, this is the exclusive means, the only means by which you can challenge a candidate's nomination papers. Time is of the essence. Our Illinois Supreme Court has said it is vitally important that nomination objections be resolved at the earliest possible time. Another court has said compliance with the dispute resolution procedures contained in Article 10 is essential to the orderly pre-election process. Time is of the essence. When the objections are filed, assuming they're filed on the last day, which most of them are, and that day will be November 30th. On November 30th, there's only going to be 84 days left before the February 22nd, 2011 election. And then keep in mind that we just don't have election day anymore. We really have an election period. We have early voting in Illinois. And early voting is going to start on January 31st, which means we have to have a ballot programmed, printed, and ready for voters to make these elections on January 31st. So by the time the objections are filed, there's going to be 62 days until the early voting starts. In 2007, we had 208 objections filed against city candidates and aldermanic candidates running for office in the city of Chicago. 208 objections. we issued decisions in all of those cases within 30 days. It's important because we need to get these cases resolved so we know which candidates are going to be on the ballot and which candidates are not going to be on the ballot. And we also have to build in the fact that there's a thing called judicial review, so that if you don't like our decision, you can take it across the street to the Daly Center and file in the Circuit Court of Cook County, and you can appeal the decision of the Chicago Board of Election Commissioners. And if you don't like that decision, you can take it up to the Illinois Appellate Court. And if you don't like their decision, go up to the Illinois Supreme Court. We had 2 cases that were decided by the Illinois Supreme Court in 2007, the Friday before the election. And I don't want to tell you the consequences of what that resulted in, because it wasn't pretty, and it ended up in federal court. So we need to get these cases decided as quickly as possible, and we're going to put pressure on our hearing officers, who are going to be putting pressure on the parties, the candidates and the objectors, to move these cases along as quickly as possible. There is really no time to delay. And although I'll point out in a few moments, ordinarily the general rule is we do not grant continuances, except for good cause shown. But I'm here to tell you that there will be an election on February 22nd, 2011, whether we're ready or not, and there are no continuances. So we're going to push hard to move these cases along. So be prepared. Be prepared. This outlines a little bit about the nature and structure of electoral boards. These are our special bodies, public bodies created by statute, whose purpose is to hear and decide objections to candidate nomination papers or objections to petitions having to do with referenda. I mean, most of what we're talking about here applies to both. So these are special public bodies. They are considered to be quasi-judicial, meaning they resemble a court, they resemble a judge. They have certain judicial powers. This is a legal proceeding. These are legal proceedings. And there are basic legal rights involved. So it's important that you understand the process. And if you're not familiar with the process, you don't understand the process, we always encourage you to seek legal counsel. Now, I say that, I'm a lawyer, so I'm trying to create business for lawyers, but it's really true. If you really don't know, unless you're very well schooled in this process, it could be very complex. And that's why we're doing this seminar today, to try to take some of the complexity out of it, some of the mystery out of it, and make it a little bit more understandable. But it can be complex. And if you're unsure, I would encourage you to go out and look for help. Look for someone who's familiar with election law, because it does affect very important rights.